Good morning, everybody, and welcome to the District of Appeals. We will be hearing argument in three cases this morning. The first one up is GINA VAUGHN versus DC Office of Employee Appeals, number 25 CV 007. Whenever you're ready, counsel.
Yes, good morning. May it please the court. My name is David Branch. I represent the appellant, GINA VAUGHN. There are three issues. This is an appeal from a petition for review denied by the DC Superior Court, appealing a decision issued by the DC Office of Employee Appeals. There are three issues on this appeal. The first issue is that the court's decision violates the law of the case principle. The next issue is that the court's decision lacks substantial evidence. And the third issue is that the denial of a hearing at OEA and the consideration of evidence not relevant to the issue was improperly considered by OEA in the affirmance of this decision. So court is aware this case involves an individual who was subjected to a reduction in force in 2011. She was in a 334 IT position at the Metropolitan Police Department. Metropolitan Police Department also created a 2210 IT series position. The DC Superior Court Judge Epstein held earlier that she should have been allowed a competitive round of competition in the 2210 position when she was before she was terminated, and that was denied.
Can I just ask, you listed three issues in this appeal, the third of which was a failure to hold a hearing. When I look at your brief, the issues presented, there are two. When I look at the issues that are briefed, I also see two. There's three sections. One's a standard of review, and the other two are the first two issues you listed. Where did you make that argument?
Your Honor, I think it's just subsumed in the argument that the OEA decision was improper, that the OEA decision lacked substantial evidence.
I mean, I could see. Okay, I can see how those two could sort of intersect. It was not clear to me that you were making an independent argument about failure to hold a hearing, but I won't hold you up on that.
But on that substantial evidence point, we have evidence in the form of the position descriptions themselves, testimony from the adjacent Gamble case, and the interviewing panel's assessment, all indicating there's a lack of sufficient similarity and things that OEA could have based its decision on. How do you get around that, or how is that not substantial enough for us under our traditional standard?
Your Honor, well, if we can break down the different categories of evidence. In terms of the reliance on the Gamble decision, what the OEA administrative judge did was to extract evidence from a different case and say, I've reached this conclusion that people aren't able, who are in this particular series, 334 series, have not been able to perform the duties in the 334 series. I think that that's a separate issue from whether she should have been placed in the 2210 position and given the competitive round of competition. I mean, when Judge Epstein made the decision that she should have been placed in the 2210 and allowed to compete there, the only thing that remained was for OEA to determine whether she was actually placed there and given the rights afforded to someone who's allowed to be placed in a competitive level, here tenure and bumping rights.
You would agree, counsel, wouldn't you, that, I mean, putting aside law of the case for a moment, that Judge Epstein's decision did not grapple with substantial similarity or sufficiently alike at all?
I agree with that, but I don't think that was that's not required in a typical reduction in force. The only thing that's required is that you identify people who are in this particular series who are given bumping rights or their tenure is considered in the decision to decide who gets subjected to the reduction in force.
But isn't that, I mean, that seems to run headlong into the regulation 2410.4, which seems to set forth three requirements for competitive level, for being part of a competitive level: same grade, same classification series, and sufficiently alike.
Your Honor, if they are in the same position, Judge Epstein determined that she should have been considered in the 2210 series. That's the same position. So there's.
So by
there's no
definition,
difference.
they're sufficiently alike is what you're
It's the
saying.
same position. It's the same duties. And so that takes me to the next issue in
Can I,
terms
can I
of.
just nail you down? Do you agree with Judge Schenker that if she, or maybe prior to being reclassified as a 2210, that could only be because the two positions were sufficiently alike?
Yes,
Okay, so on appeal, we now have some findings that say they weren't. So this is one of MPD's arguments that these really are not sufficiently alike. So Judge Epstein made a mistake. Is, you know, one thing you could draw from that. Another thing you could draw from it is, I think what Judge Schenker said, which is you both need to be in the same classification and have sufficiently alike duties. I find that a little bit strange of a way to think about it. But it seemed to be how Judge Ross was thinking about it. But if we find that they are not sufficiently alike, why wouldn't the answer just be, okay, well, then she shouldn't have been reclassified as 2210 and Judge Epstein got that wrong? Like, don't we have to evaluate, well, don't we in either case have to evaluate whether or not these positions are sufficiently alike to be, to entitle her to a round of competition?
Your Honor, only if the court rejects completely Judge Epstein's finding. Judge Epstein said she should have been in the 2210 series. So if she should have been in the 2210 series, the only thing that remains was whether they afforded her the bumping rights or the tenure that's afforded in a position in making the decision to terminate her employment.
Yeah, I appreciate that point, but why wouldn't, if the two positions are not sufficiently alike, why doesn't that mean that Judge Epstein's ruling is wrong? Under your view of how this should work? Because he didn't even conduct that analysis.
Yeah, my apologies.
He did not really even conduct that. He didn't do that.
He determined that based on MPD's failure to basically move her over into the 2210 series, that, you know, she should have been placed in the 2210 series. But even looking at the OEA administrative judge's determination that they were not substantially alike, we've listed the position descriptions. I think there may be 5 different categories in these positions. Ms. Vaughn had been in her position since 1994. And based on just looking at the position descriptions for each of these positions appear to be substantially alike. But even if the administrative judge found that there was a question of whether they were substantially alike, the administrative judge should have given petitioner an opportunity to bring in some HR expert or some afford her an opportunity to prove him wrong and to show that these positions were substantially alike. Instead of doing that, he made that determination without a hearing, then considered this evidence from this that he considered or heard in a different case, and basically made a final decision without giving her an opportunity to even present evidence if he did not accept just this comparison, this layman's comparison of these two position descriptions.
Can you, oh, sorry.
Go ahead.
Can you remind me, did you request a hearing?
Your Honor, I
before
did
OEA?
represent the petitioner when we were before OEA. There was a discussion on whether we would have a hearing or whether the judge would first receive briefing. He decided, okay, I'll receive briefing. But after he received briefing, he issued the decision saying I've made this determination, this is decision. There was no additional opportunity.
Well, what about, I mean, you say additional opportunity, but I think it was at that point that that MPD submitted the position descriptions. And so why couldn't your client at that point have submitted anything on paper or an affidavit or, you know, anything that short of a hearing, but any evidence at that point? My understanding is that she did not.
Yeah, we did submit our response, making the argument that looking at these position descriptions, which is the issue that the administrative judge had put before the parties, I have to make this determination whether these positions are substantially alike. Basically, make your best argument that these positions are are or are not substantially alike. And that was the extent of the briefing at OEA. It did not go beyond that. There was no further opportunity to request a hearing or request expert testimony to demonstrate that these positions, in our view, were substantially alike compared to the decision that was ultimately made.
Just going back to a question Judge Deal asked, do you agree that Judge Epstein's ruling is before us as a procedural matter on appeal?
Your Honor, I understand the district's argument, and of course, our position is that Judge Ross's decision was wrong in terms of reaching this, sending it back to OEA to say that it was substantially alike. I think that the district could have made a request or appealed that decision, or perhaps through some exception, attempted to appeal that decision if they were convinced that the decision was was not correct.
Oh, I thought in Gamble, we had rejected an appeal in just that posture. Maybe I have that mistaken, but I would think if we had a ruling from Judge Epstein that says, I'm going to remand the case, that it's just not final yet. There is no order, there's no decision to appeal at that point. Well, why do you think they could have appealed that immediately?
Well, Your Honor, I agree then that perhaps they could not have appealed that decision.
Yeah, and that, I mean, it intersects with the law of the case argument, which is, I've had this argument before, and I always find it a little strange to say, well, I mean, even if it's true that Judge Ross made a mistake in revisiting what Judge Epstein did, I'm not sure it's true. And I'm not sure he revisited it, but I think you have a decent argument that he did. But even that's right. Ultimately, you know, we have this case, Guilford is probably the strongest case on this. We still need to determine whether or not what Judge Epstein did was right. It can't be that because, you know, the case got remanded and the second judge shouldn't have second guessed the trial judge that therefore we can't. I mean, we ultimately, you know, if you're right about the law of the case, what good does that do you? Because don't we have to independently analyze Judge Epstein's ruling too?
I agree. Yes, all interim orders should be reviewed and determined by the court, particularly when it's relevant to the final decision here. I'd like to just reserve a couple of minutes for my.
Yeah, I should have asked you that at the outset, but we'll be sure to give you time on rebuttal too.
Thank you.
Before you sit down, I want to ask you too, what do we make of, and Judge Scott referenced it in her ruling, sending it back to OEA, where your client did get to interview, and an interview panel in 2012 made a determination that her credentials didn't likely match up well to this, and she would require extensive supervision despite prior training. Should that not be part of the calculus, and why?
You know, absolutely not, Your Honor. I would just say that generally, when there are reductions in force, people who may perhaps have fallen out of favor or for whatever reason, it's quite often that those people end up on lists for being riffed. And now she's already been riffed and she's challenging the riff, and they're bringing her back to interview for this position because she's saying that I should not have been riffed. I should have been placed in this 2210 category. And now we have a subjective panel making a decision about her qualifications. We don't know anything about the interview panel. We don't know anything about, you know, the questions that were presented at the interview panel. I just don't think you can place any value on comments made by an interview panel for someone who's already been ripped from their position, particularly someone here 15 years of employment in this IT position. So I don't think we can place any value on that.
Counsel.
Thank you.
Thank you, counsel. We will hear from the district.
Good morning, and may it please the court, Romina Lalaurie arguing on behalf of the district. Before jumping into the discussion of whether or not the positions are sufficiently similar, I'd like to first address the other requirement of the competitive level definition, which is that the positions also have to be in the same classification series. I think that this is just an easier way for the court to resolve this case for two reasons. First, because the regulations make clear that employees are assigned to competitive levels based off of their position of record, and here Ms. Vaughn's position of record, as established by her official employment paperwork, and as she even admits in her brief was in the 334 series. And second, because this argument was effectively conceded by Ms. Vaughn. The district briefed it in their opening brief. It was our first of two arguments, and Ms. Vaughn could have submitted a reply brief or could have even addressed it this morning, but failed to do so.
Well, so let's say, here's the evidence. All 334 employees are to be reclassified as a 2210 employee. MPD drops the ball on one of them. Everybody else gets reclassified as 2210, and without explanation and through nothing but administrative error, a 334 employee does not get reclassified as 2210. You think they can't challenge a RIF on like, oh, they messed up when they didn't reclassify me as 2210?
That's correct. They can't challenge their classification during a RIF appeal. And I think that's made clear from the court's decision in Gilmore, where an employee was challenging the RIF based off of the fact that they believed a year prior they had been misclassified to a different position. And the court there said that there is a normal grievance procedure that employees have to follow, which is the regulations provide at any time you can challenge your classification to the director, but you can't do that during a RIF.
Can you point to me? I couldn't find it. Where did you guys make this argument below? The Gilmore argument that you have to challenge a classification prior to a RIF?
So I think the district just made the general argument, which is she's not in the 2210 series, so she can't compete for the 2210 position. I think to the extent that this argument was not made, Ms. Vaughn also did not make the argument that we forfeited it below. So I think they forfeited their forfeiture argument as well.
Well, we tend not to apply that doctrine very often. I mean, the whole waiver of the waiver doctrine is something that's discretionary, and in a case like this, it would be surprising. I mean, this has been going on for a long time. And if your argument back in, I don't remember when it was, 2012, was they can't challenge a classification after a RIF because that's procedurally improper, well, then you've just wasted 14 years of our time if we now consider that argument for the first time. Well, like, why would we do that?
I don't think it's the court considering it for the first time. I think the district has consistently made the general argument, which is that employees have to be in the same classification series for the position that they want to compete in. This was made at the OEA level.
Right,
Superior.
those two sound like very different arguments to me. One is you have to be in the same classification series in order to challenge this. And two is, as part of that argument, you cannot say, and you should have been in that same series, you were misclassified or you were improperly not reclassified. Those two sound very different to me.
I would characterize it the second as just kind of a reasoning for the first. You have to be in the same classification series. And the reason for that is because both RIFs are formalistic, and also there are other ways that employees can challenge their classification.
Yeah, I mean, maybe you would classify it that way now, but in front of Judge Epstein and back when you went back to OEA, nobody ever classified it that way. Nobody ever said, why are you even considering this? Don't consider this. A challenge to a classification needs to be made prior to any RIF. I mean, it's a new argument. It's not how I read Gilmore either. I mean, Gilmore was a case where the employee was reclassified as part of a promotion, sort of at that point had an impetus to challenge that reclassification in a way that I don't know what Ms. Vaughn's impetus, like at what point, I don't know that she knew that some people were reclassified as 2210, but not her. Like none of that's developed.
Well, I think that Ms. Vaughn had 10 years, for example, to request a desk audit or challenge her classification. And regardless of like whether or not she knew or actually knew, there are certainly incentives that employees have to challenge their classification and to regularly seek these desk audits. They can be subject to promotions, higher pay. So I think that up to those, Ms. Vaughn had 10 years, and the time that she cannot challenge it is during a RIF. And there are good reasons for that.
Can I just pause? If she had been reclassified as a 2210 employee, would that have been tethered to a promotion and a raise in pay?
I'm not sure. I don't think the record reflects one way or the other, so I don't think I can answer that question.
The 2210 says it's a 12, right? And we know that at one point before this RIF, she moved from an 11 to a 12 in the 334. So that would have potentially, I mean, you would say that we can reason from that would have had a promotional impact.
Yes, at one point in 2001, it's unclear the month that she was promoted from a grade 11 to a grade 12, but yes, at one point she was promoted from a grade 11 to a grade 12. That's correct.
At which point her incentive to challenge the classification would seem to be none.
I don't think that's true because there are other reasons why especially once Mr. Louis' position was filled in 2005, certainly Ms. Vaughn knew that there were IT specialists within her specific agency, and therefore she could have regularly or she could have requested a desk audit to seek a reclassification or to seek a higher grade or a promotion of some kind, and she didn't. And again, to address the fairness concerns, first I would just look to the fact that RIFs are designed to be formalistic. Agencies have very little discretion when determining which employees to keep and which employees to terminate. Competitive levels are created based off of the positions. Agencies will compare the objective qualifications of the positions, not the subjective qualities of the employees that hold those positions. And of course, RIFs are meant to be challenged on very limited grounds. So I think that this argument is important because if we allow employees to challenge their classification or the agency's failure to reclassify them 10 years ago or several years ago, it would basically mean that employers or agencies can't determine the retention rights of employees when conducting RIFs. Yes, so I think at this point, if there are no further questions on the first argument of the fact that they're in different classification series, I'll address whether or not they're sufficiently similar. I'd like to just make a few points on this. The first is in the opening, the counsel on the other side made an argument about sufficiently alike is not a separate requirement of the RIF regulation. I think the regulations are pretty clear that positions have to be in the same series, in the same classification grade, and also have to be sufficiently alike in responsibilities, qualifications, and requirements.
Can you just explain that a little bit in practice? How could one have a position that meets the first two requirements, but not be, same classification, same description, but not sufficiently alike? Why does that make sense?
So two responses to that. First, I think that this scenario, the regulations contemplate this scenario. So there are two regulations that I can point to where the agency can classify or can create separate competitive levels based off of employees in the same classification series and in the same grade. So for example, in section 2411.2 and 2412.6, it says that agencies have to provide a written justification anytime they separate employees of the same series and the same grade into separate competitive levels. So that contemplates that there will be cases where employees.
True. I appreciate there's a regulation that says something. But were there separate competitive levels within the 2210 series?
I can't answer that one way or the other because I don't think the record reflects whether or not there were, but there are scenarios where you have a computer specialist, for example, or an IT specialist that is primarily focused on like software development and an IT specialist that is mostly focused on network design. And in that case, I could assume or picture or contemplate that an agency would want to separate them into different competitive levels because they're performing different duties and responsibilities.
Those would have different position descriptions or?
So for example, based off of the staffing pattern in supplemental appendix 69, some of the proposed positions had a parentheses that would differentiate between different types of like IT specialists or different types of other positions that the MPD was creating at the time. So I don't think it would change the series or the grade that you're in, or even the position description. There might be a parentheses that would differentiate you into a very specific type of that position description, but I don't think it would be formally reflected in your series grade and formal description. And so for that, or I guess when you're creating a RIF, you want employees to be able to conduct the exact same responsibilities, duties, and have the same qualifications from the employees that you're terminating. And so even if they're in the same series or grade, their official position descriptions might just have different responsibilities, which means that they can't be interchangeable with the position that they're replacing.
If we look at these descriptions, the 334 and the 2210 series, and say, well, hey, they're really not sufficiently similar, does that perforce reject Judge Epstein's ruling that she should have been classified as 2210? Or because it sounds like you're saying no. It sounds like no, you could coherently say she should have been reclassified as a 2210 employee. You're treating the sufficiently similar as an additional requirement, not something that is baked into that classification. And that's still, I hear you saying you can have different competitive levels within a classification.
Yes.
So, okay, I don't, how would one draw the conclusion that she should have been reclassified as 2210 without making the decision that they're sufficiently similar?
I think if you accept Judge Epstein's decision, you would essentially just be going through her employment paperwork and crossing out Series 334 and replacing it with Series 2210. But the official position description that's associated with all of her official employment paperwork is still the description that we have in the record. And I don't take Ms. Vaughn to be arguing that we shouldn't be comparing those position descriptions. I think they rely on those position descriptions, but the only source of disagreement is the extent to which they are similar or different. So even if you accept that she should have formally been in the 2210 series, there's still this additional analysis of whether or not her position description is sufficiently similar to Mr. Aloui's. And I think that also even if there are certain reasons why or certain similarities between the position descriptions, that's not enough for this court to reverse A.J. Lim's finding that there was substantial evidence going in one direction.
Do you want to just spell out for me why you think they're not sufficiently similar? I mean, I think what OEA says, which is kind of echoed by Judge Scott, is this is somewhat true, but I mean, I'll say when I read the descriptions, they're a little hard to parse. That the 334 series is a little bit more like a computer help desk, and the 2210 series is a little bit more like programming. Is that roughly the argument?
Yes. So in terms of the 33412 position, they are performing help desk functions, which means they're helping users that are using the software kind of log in, respond to like basic problems that they're having. Whereas the 221012 IT specialist position is mostly focused on helping software developers make sure that when they introduce new features in the district's applications, they're not like creating a new bug or destroying the entire application. So I think that they're just completely different functions. One is mostly focused on users' ability to use the software, and the other one is testing the software for software developers.
So I'm not sure if this is in the record. Maybe you can't answer it. But it seems like it would be impossible to eliminate computer help desk as a position. So when 334, when that position was eliminated, was there something else that amounted to 334, the computer help desk side? Or was that all 2210?
Again, I don't take Ms. Vaughn to be making this argument, but if you look at Supplemental Appendix 231 to 237, which is the Gamble evidence, I think there the administrative law judge found that MPD was outsourcing all of the help desk functions to a different agency, so it didn't need these positions anymore.
That's helpful. Thank you.
And also, this also might not really be before us, but can you just educate me on what the difference is between laterally competing for a job if you are within the same competitive level, and what Ms. Vaughn did here, which was apply for the 2210 as sort of a normal applicant? I mean, what's the difference between laterally competing for the job?
Yeah, so lateral competition doesn't look at your like the subjective qualifications of the individual employee. It will just create the agency will create a list of all employees whose official position description matches that competitive level. And then it'll look at their tenure status based off of their years in service. There's certain preferences or boosts that may be given, but it's not based off of the performance of the employee whatsoever. Whereas I think reapplying for that job, the agency presumably would look at her individual qualifications, her subjective qualities as a candidate. But for the competitive level creation, the agency just has very little discretion. They have to follow the tenure criteria that's laid out in Chapter 11. One last thing to respond to, I'm sorry, is I think counsel on the other side made a point about the hearing. I think this was sufficiently discussed, but I would just make 2 points to that, which is there was an opportunity for them to also, for both MPD and Ms. Vaughn to engage in discovery, and MPD requested documents from Ms. Vaughn that would show one way or the other of whether or not the positions were sufficiently similar. And Ms. Vaughn not only did not request an evidentiary hearing, but just said, please refer to all of the briefs and arguments I've made prior during the administrative proceeding. So it is reasonable for A.J. Lim at the time, or at that point, given that there was no request for an evidentiary hearing and no new evidence besides the position descriptions, decisions to not conduct a hearing. And as this court knows, evidentiary hearings are discretionary, and there's no argument about how they abuse that discretion.
Thank you, counsel.
Thank you.
And we will give you a couple minutes for rebuttal.
And just on the final point, in terms of requesting an evidentiary hearing before OEA, I'm not sure the basis for the representation made by counsel that the request was not made before the administrative judge at OEA. There was a series of, well, it's preliminary hearing at OEA where there was a discussion about how the case should proceed in light of the Superior Court's decision. And there was a discussion about whether the only option the administrative judge would consider was some limited discovery, but then just briefing or making an argument on how the court should decide the case. There's never an opportunity afforded for a hearing before OEA. So, and I'm not sure how that can be represented to the court when it just doesn't appear in place.
I think all she said was that you didn't request a hearing. And if you did, then it seems like you could point me to that.
Well, the proceedings before the administrative judge was basically a phone call with the administrative judge and counsel on how to proceed. And the initial request would have been, yes, we want to proceed to a hearing. And the administrative judge decides that, well, no, I'm not going to do that. I'm going to allow some limited discovery, and then you can brief the issue.
I can't tell if you're telling me what happened or what you suspect happened.
I represented.
Right. So.
But there's no recording of any of this. This was just a phone call with this is how the proceeding was decided. It was a phone call with the administrative judge at OEA on how to proceed. In terms of Ms. Vaughn's background and this representation that she was in a 334 series, and that was primarily help desk, and as opposed to the 2210 series, which was software. Ms. Vaughn stated, and we indicated in the brief before OEA and in the Superior Court, that she had performed duties beyond just help desk duties. She had actually performed some software related work. So the representation that she was basically in a 334 series and only had performed help desk duties is just not accurate. In terms of the lateral competition, the response is very simply, it places you in a completely different category in terms of competing for a position. If the agency decides to proceed with reduction in force, if you were placed competitively and get afforded lateral competition, as I stated earlier, that just means that there's a decision made on your tenure and based on your position, whether you would bump someone and remain employed, as opposed to here, Ms. Vaughn was required to actually reapply or apply for the 2210 position after she was terminated. So she was placed at a disadvantage.
Yeah, I wasn't suggesting by my question that I thought that her ability to apply for the job separately was sort of remedied the situation that she is complaining about. I was just curious about what the actual difference is.
And so just in conclusion, our position is that Judge Epstein got it right. He in his decision that she should have been placed competitively in the 2210 position, which here would have had an impact on her being ripped from her position, and beyond placing her in the 2210 position, there's no requirement that a determination be made that the positions were substantially alike. And we would request that the court reverse the decision of the Superior Court and reach the same conclusion that Judge Epstein reached, and find that she should have been placed competitively in the 2210 position, and she would have been spared from this rift. Thank you.
All right. Thank you, counsel. We will take the case under advisement. We'll now hear argument in this morning's second case, number 25 CM 157, MARQUIS Daniels versus United States. And Mr. Goldberg, you can let me know if I've pronounced your client's first name correctly. Whenever you're ready.
Thank you. Richard Goldberg on behalf of Mr. Daniels. I'd like to reserve 5 minutes for rebuttal. At this point, there are two major issues in the appeal. The first is sufficiency, whether Mr. Daniels had the purpose and knowledge to threaten, as required by Carroll, and whether his words would have caused the ordinary hearer in the circumstances known to the parties that to believe that he would carry out his threat. And the second is whether the attenuation doctrine, as established in Brown v. Illinois, and its three-factor analysis, can be shortcut only because the intervening circumstances, the second factor, are a crime. I'd like to start with sufficiency. The video shows that Mr. Daniels is clearly sad and upset. He says things like, "I don't love her. I hope God kills you. God kills you. I don't care about you. I wish I never was born from you." And although we don't have his testimony, we have a lot of video. We know how he acted. We know how police responded. We know how, in some ways, his mother responded. And each time he speaks the words that are reportedly a threat, and admittedly facially a threat, nobody acts like it's a real threat. Nobody does anything different. There's no evidence in the record that they do anything. He's sitting on his bed. He's looking at his phone. He's smoking a cigarette. And what we have is the police he's guarding the door, holding him, just as they were before. There was a police officer with his mother. And we have the reaction of his mother as well, which is that she's clearly dismayed. She says things like, "I'm just tired. You see the room," presumably referring to the mess in the room. "You know, we have all these case managers, but everything just falls on me." Everybody, I think, is sad and dismayed. But in the circumstances known to the parties, Mr. Daniels is not saying he actually intends to kill his mother. And the third thing we know is that had he wanted to leave the room, at one point, he actually says, "Excuse me," and tries to get by the officers. There's no chance that he's getting out of the room and then getting past the other officer as well to his mother.
Can I ask, I mean, I don't think the question is whether or not he intended to follow through on the threat. And I don't think the question is whether or not a reasonable listener would fear that he would follow through on the threat. I think it's whether or not a reasonable listener would fear bodily harm. So, you know, look, I think I could agree. It would be very tough to say that anybody would think this guy, either with cops around or when the cops are gone, plans to kill his mom. But would a reasonable person be put in fear that if, you know, once the cops are gone, he's gonna hurt mom? Given what seems to be a fairly disoriented state, repeated threats of violence, and that, I think, well, at least a rational fact finder could conclude that that is a reasonable thing a listener would understand, and then that gets you to intent. The question is, well, did he intend that? Well, what else would you intend when you tell somebody you're going to kill them, other than to put them in some fear? Even if you don't intend to follow through on it, you're trying to scare them. So where have I misstepped?
In the last part, I think for sure, the statement, "I'm going to kill you," can be a number of things. It's a thing often uttered in frustration. It does not mean necessarily that you're going to hurt someone. Could, but it doesn't necessarily mean that. And I think in these circumstances, it's clear that he's equating it with disrespect. And excuse my language as I, say what he said, but he says, "I'm going to kill you." And then the officer asks him a question and he says, "Fuck you too. Fuck you and fuck her." I think that's what he's equating "I'm going to kill you" with, which is this ultimate show of disrespect. You're right. I think I agree that the question is whether the person would be put in fear of bodily harm. But there's just nothing in these circumstances, in these parties who know each other, says there's bodily harm at issue. In fact, when the police show up, she says, I'm just sick of this. And that seems to be her demeanor.
But I mean, she did call the police.
Yeah.
So if she just thought this is the way it's been going with my son for the past X number of months, years, and he does this and I've got nothing to fear, presumably she would not call the police in that situation.
I don't know if that's true. For one thing, we don't have, what we have is that there was a disturbance, a family disturbance of some kind. And when they show up, she says, I'm sick of this, and the things that she says in the video are, I think she just needed help with him. That's clear at the end when she says, we have these case managers and I just can't do all this myself. That's not an expression of fear of harm. It's just being overwhelmed. And it's understandable, I think, that when you hear her talk, it's clear that she's just overwhelmed with her son. As police said, he's very difficult to deal with. A person who has called the police because she fears she's put in harm does not tell them, God, that room's so messy. I mean, that is just not on the mind. That this is really her frustration with dealing with him. But there just isn't indication that she thinks she's going to be harmed by him. Although she does say she has a heart condition and, this is very difficult.
Is that a necessary element of threats? Subjective, that the listener, in fact, fears harm?
No, but it's an indication of what an ordinary person in the circumstances known to the parties would fear.
Sure.
So let me ask you about another particular nuance in this. I get that your theory is going down this line that I'd like our choice of language for it. In a previous case, we called it a feisty lament. And I get these points that she doesn't appear to have a fear there. But to the observer, does it make a meaningful difference to you that if the cops had not arrested him, if there wasn't some form of separation there, she would continue to have to deal with him? He would be on the lease. There would be potential for a threat to be carried out if it was in fact a real threat, which I get that you don't accede to.
I'm not sure I understand your question. Are you saying that there was a threat of harm in the future because of what he said at the time?
Does it make a meaningful difference compared to other cases where, for instance, the Thomas case you cited, where the individual could not have carried out the threat because they were handcuffed, there were two officers, you briefed that aspect of it, but in that case, the threat was towards an officer who this person was unlikely to see again. In this case, Miss Nicole, the mother, would be with MARQUIS after this if they weren't separated in some way by the police arresting him there.
So his words taken at face value, which is what those cases require, don't talk about, when one is about hunting someone down, doing something in the far future. Because I think there are two time periods we're talking about. One is the immediate future. I'm going to walk in this room, is to say, I'm just about to walk in the room. It is not to say I'm going to walk in this room tomorrow or some other day. And another is the far future. I'm going to hunt you down and get you, or watch your back. That sort of threat. Don't come around here again. That's a thing far in the future. His words are about the immediate future at most, not about something far in the future. And although everyone is ordinarily concerned with family disturbance about what could happen in the future and violence in the future, and that's a very important and reasonable concern, that's not what his words say.
Well, so not the exact words that were the focus of the threat charge, but obviously we look at all of the surrounding circumstances, as I think you've acknowledged. And he said something to the effect, I'm going to burn this house down. And obviously he wasn't talking about in the next 2 minutes, but that reflected some reference to future violent acts that weren't going to be carried out right there when the officers were standing right there.
I don't recall where in the video he says, I want to burn the house down, but that's not what he was convicted for. He was convicted of saying, I'm going to kill you. And I think you're right that it matters, what the circumstances are, but it's circumstances known to the parties. The question is, I think, at issue here are the statements, I'm going to kill you, a threat of something in the future. And at most, they refer to the immediate future right now. There's nothing, I don't think there's anything about those words that convey, watch your back next time you come, or, something about the far future.
I
that answer the
don't really follow the idea. Like, I'm not going to do it when the cops are here, but once they're gone, I'm going to kill you. Why isn't it just as susceptible to that interpretation? I mean, is the burden on the government to show, well, unless otherwise previewing a future act, all threats are presumed to be immediate. That would be a funny presumption, I would think. And I think, that you could tack on, reasonably understand his statements to be, once these officers are gone.
In a sense, it is the burden. The words have a facial temporal meaning. And I'm going to do this ordinary means I'm going to do it in the immediate future.
I don't think that's true.
In order to,
I'm going to go home today after work. Doesn't mean I'm leaving in the middle of your argument. I'll stick around for, 6 or 7 hours. So why does it mean the immediate future? Why does it mean while the officers are here?
so I'm going to go home today after work, expresses the temporal time, which is after work.
I'm going to go home today.
Mhm.
Let's lop off the after work. I will go home today. I'm going to go home today to follow the verb tense.
Well, that too, I think. I'm going to go home today expresses some question about when it is, whereas I'm going to go home, I think would mean I'm out. So if you said, I'm going to go home, I would assume you're going to go home now. Whereas if you said, I'm going to go home today, we'd say, oh, well, it's sometime today, don't know when.
I'm going to get in shape.
I think implicitly, yes, that is about the future.
Okay.
Or present, I'm not making a statement about that,
Seem
but
quite
I think
capable of
in this,
immediate-
I'm sorry?
Capable of immediate accomplishment, right?
That's right,
Dare
it is
you.
not.
right.
Whereas an ordinary state, for instance, I'm gonna go pet that dog. That does not mean I'm gonna find the dog in the future, although it's possible I would. It means I'm gonna go pet the dog now. And I think that what we know from the cases that talk about whether it's a threat about the future is that there has to be some indication that it really is about the future.
I don't see. I kind of think it goes the other way, which is, Thomas is sort of your best case. But Thomas, the threat itself connotes some immediacy. I should or will go grab your gun and slap you with it, something like that. Where it's a fleeting interaction with an officer that he would have no expectation to interact with again in his life. So really, the only interpretation of it is he's going to do that now, and the fact that he is totally incapacitated, handcuffed, and surrounded by other officers tells you, well, that's not a serious threat. But if you take sort of that immediacy is kind of baked into the scenario. This scenario does not have any sort of immediacy to it. This is, I'm going to kill you, and maybe not today, maybe not tomorrow, seems like a fair implication to read into it, where it's just, one of these days. I don't know. Maybe you understand it differently. I just don't really think our language works quite the way you're positing.
I think in the question of whether a threat is a threat about the farther future, that the cases say there has to be some indication of that.
What's that case?
It's going to be Thomas, Lewis, or High. I can tell you on. I'm back. So, and I think we should also note that the third issue, which is in this sufficiency question, which is that the cases describe, a lot of the cases are about people being handcuffed and not able to do anything. And those are all from an earlier time where we're essentially looking at a record. What people have said was the situation. Here we have video. And they all seem to follow the expression I think that the cases are giving is not going to happen. He is just not leaving that room. That officer is not letting him out. And if he got out, he wasn't getting past the other officer, but he wasn't getting out. And the one time he actually got up and said, excuse me, and he actually tried to leave and he wouldn't sit back down. The officer had no trouble stopping it. He just was not leaving the room. And so on the immediacy question, leaving aside whether there's a threat about the far future, he just wasn't leaving the room and he wasn't able to do the thing that he said he was going to do.
Taking into consideration some of the other contextual things that were going on there, what impact do you think we should give to his statement that he had just been physically assaulted by a stepbrother there? Like, does the fact that he's complaining of suffering physical violence mean we should take the threat as more serious towards physical violence?
I don't think so. In fact, the opposite. I think that it just shows that he's upset with his mother that she didn't stop the violence. You should have done this for me is essentially what he's saying. It's actually what he says a bunch of different ways. You should have done this for me. You don't do anything for me. And so I'm
You
not
don't
doing anything
love
for
me,
you.
I don't love you. He appears to be listening to a self-help tape that has to do with parental love of children, et cetera, and having a pretty good, I won't deem it reasonable or unreasonable, pity party for himself there. I'm completely with you on that point.
I think that's right. And also the way he acts, at most he sits on the bed. Otherwise he lays on the bed. That does not express future violence.
Well, there's a moment where I was with you on that, watching the video myself for most of it, but there's a moment where he jumps up and his voice really rises and the volume of his voice rises. And I was pretty scared myself when I watched that. So it's fair to say he was quite volatile during this.
I think at one point, yes, he was very upset and stood up and then sat back down and then laid back down. It's not that he wasn't angry. He was obviously angry and very sad.
I think unpredictable, it may be the key word here, which goes to the threats, the validity of the threat charge, is how unpredictable is he?
Maybe unpredictable in that he sat up and at one point he screamed, but he goes to the officer and says, "Excuse me." I mean, he doesn't, try to bust at the door. I think, yeah, he's probably unpredictable, but not unpredictably violent, unpredictably sad and upset with his mother. If I can turn to the second issue.
We'll give you a couple minutes.
Which is whether the attenuation doctrine analysis established in Brown is followed. This is a bit of a confusing mix of cases. You have this original case that the government cites Clark. Clark is based on Bailey. And what Bailey says, Bailey essentially ignores the normal Brown analysis. Probably understandably, Brown has a line at the end that says, that this is confined to its own facts, where it's very limited ruling, I should say. And Clark essentially just looks at the second factor in the Brown analysis and says this is a substantially intervening act. In Bailey, it's an arrest, and then there's a search incident to the arrest. Clark takes that much, much further, does not apply the Brown factors. Now, Clark is from 2000, and a lot of courts had just applied the Brown factors. And I think in the Supreme Court's case called Strife, that made clear that the Brown factors were the analysis for the attenuation doctrine. And so for that reason, I think Clark has a broad reading of the holding and a narrow reading of the holding. The broad reading is any crime is enough, regardless of the other factors. And a more narrow reading is that any crime against or to police is sufficient under the second factor. And I think the narrow reading, the broader reading, I think includes some dicta, which is to say that any crime is not necessarily the holding.
Why would it be relevant that the crime is directed at police officers? I mean, all of this really goes back to Wong's son, right? Which is the question of whether the fruit was obtained through exploitation of the illegality. And if an intervening act towards anyone breaks that chain, then I just don't understand why it makes a difference if the act was directed at a police officer or not.
So I don't think it's easy to square against the Brown and Strife factors, but the explanation that many courts give is that we need to protect police, that action against police in an arrest is pretty common, and that's too much. But I don't think it survives the three-factor analysis unless you do the analysis, and which the courts at least the pre-Strife have not. So the question, I think, is how to apply Clark and in light of the required analysis for attenuation. which requires figuring out what's the temporal proximity to the police action, and which is the first factor, and the third factor, which is purpose of flagrancy of the police action. I think the police action here was particularly flagrant. He told them to leave. They wouldn't leave. The police testified, I'm not leaving just because the guy says I have to go. And so the question is, what are the intervening circumstances? And this is in some sense a causal question. I think that what pushed Mr. Daniels, I think, to talk the way he did is that he was unlawfully confined to his bedroom. And all that was happening as the police questioned his mother, who was saying a bunch of things that he obviously disagreed with.
Okay, so I have two questions. Number one, if Mr. Daniels gets up in the middle of this and skates by the first cop and punches his mom, would we sort of suppress that evidence, the evidence that the officers witnessed something because it came on the heels of an unlawful search or seizure?
I'm sorry, what was the last part?
Would we say, officers, you can't testify to that. It only came about as a result of an unlawful search or seizure?
The question is, I think there are two questions in there. One is, would the arrest be barred, which is really what Bailey's about and what a later case called Wilson's about, and then a search incident at the arrest. And then there's the act itself. I think that in a case where a person commits a crime in the presence of police officers, suppressing statements doesn't suppress all evidence after the crime, because there's the time of the crime and then there's after the crime. And Bailey—
Is your answer to me no, that wouldn't be suppressed because it's not a statement?
I'm sorry?
It's a statement rule that you're advocating for? No, you would allow that in, that wouldn't be a fruit of the seizure or search because it's witnessing an act, whereas spoken, verbal crimes are different. The hearing of an utterance is a fruit. Is that kind of your dividing line?
The question is as whether it was, how much it was caused by the police action. That punching someone is
Let's say it's as very, very much caused by the police action. If one of the officers tells Mr. Daniels, your mom, she's really out to get you. She's saying pretty nasty stuff about you. She's saying you committed these 3 crimes. And so we have a very clear causal link to the officer's actions, to the punch. He said, oh, she told you that, and then he runs and he hits her. Then do we suppress?
I don't accept that that's a clear causal link to the punch. It's a causal link to the sort of thing a person does when speaks. I think speaking is different than other action.
Okay, but I was positing that's your dividing line. It's speaking is different than act.
I think speaking is different than it's a different kind of evidence.
And then
different kind of cause.
My second question is, do you have any case that supports any case where courts have suppressed not evidence of a past crime, not statements about a past crime, but sort of actions and that constitute their own crime during an unlawful search or seizure, that a court has said we sort of suppress all the evidence of that was gleaned by virtue of the officer's unlawful stop and seizure?
Yes, there are a number of cases from the jurisdictions in our 28K letter. I'll get them for you as I come back up. I want to apologize. The government pointed out that I had a failure of shepherdizing. So one of those cases is no good for us, good for the government. But all I came up with is a civil case somehow. But the others are examples of that, and I'm happy to bring them up and talk about them on rebuttal.
Thank you, counsel. All right, we'll hear from the government.
May it please the court, Jordan Hummel on behalf of the United States. The judgment in this case should be affirmed under Clark because appellant cannot suppress his threats, which were a new crime committed after the police entry, regardless of whether the police conduct was proper. And additionally, because there was strong evidence of his guilt based on the body-worn camera, which showed the entire threat. Clark is very similar to this case where there were also threats that happened after what the court assumed was illegal police conduct, where they threatened an officer. And this court held very clearly that those threats could not be suppressed as fruit of the poisonous tree because the new crime attenuated it from the stop. And in Clark, the court did apply the Brown factors while not explicitly citing Brown. Clark effectively applied them in holding that the intervening circumstance of committing a new crime outweighs the temporal proximity question, because, and that makes sense because it's always going to be close in time, well, most of the time, when you're dealing with this kind of illegal police conduct, spurring a new crime. And they do account for the level of police misconduct, with the exception to this exception where there might be circumstances where there's an unforeseen exceptional circumstance or the police intentionally provoke a crime. So the court did grapple with these factors and came out to find properly that the new crime does attenuate it from any police illegality. And of course, there are strong.
Do you think that the cases cited in the 28K letter are just wrong? You say there is no crime that one could commit, let's say that while somebody is being beaten by several officers, a clear Fourth Amendment violation without any cause. Officers are beating somebody on the ground and they utter something to the effect of, I'm going to get you back. I had to kill you. Do you think we would admit that as, well, that's a new crime to attenuate it from the beating?
I think that's obviously a much closer call and seems to be tethered in kind of one.
Yeah, I guess I'm just wondering if you are defending a hardline rule that any time there's an unlawful Fourth Amendment search or seizure and a new crime is committed, even if directly in response thereto and closely tethered to the nature of the violation, you don't suppress. It's just not a fruit. That's the right way to think about it. Is that your position?
No, I think you have to look at you do have to look at the Brown factors, and you do have to look into the exception of what is the flagrancy of the police misconduct. Are these exceptional circumstances where you have the police, if they're beating a suspect and the suspect says, I'm going to get you back, that may qualify as the exceptional circumstance where they are intentionally provoking that threat. Here, we don't have anything close to that, where the officer is just standing in the apartment and the appellant lodges this threat that he's going to kill his mother, which is a completely different target as well. And turning to the sufficiency, if there are no further questions.
Do you want to, let's say, maybe that's a thorny topic. Do you want to give us your pitch on, let's just say that maybe it would be suppressed if there was a Fourth Amendment violation. Do you want to address the predicate issue of whether or not there was an unconstitutional search or seizure?
Sure, we can. Obviously, we think.
You can do it briefly. You can say you don't want to address it. That's fine. You've got a brief. I can read it.
Sure, I'm happy to address it. The entry was justified into the apartment by the consent, where the mother had both the actual authority as a leaseholder and the apparent authority opening the door, inviting the police in. And then the police took reasonable peacekeeping measures once they were in the apartment in what the trial court described as a hostile environment. And I think the body worn camera bears that out, that this is an emergent situation. It is unclear. The appellant is very agitated, unpredictable, erratic. He's screaming, he's threatening. He has a very aggressive tone towards his mother. So I think that did justify the police's limited actions in this case, where they are stepping into the bedroom and separating the victim.
Can I just ask, does that view depend on sort of a typical reasonable articulable suspicion analysis of whether or not they have reasonable suspicion to think he has committed a crime or is about to commit a crime? And let me maybe pitch this to you through a hypothetical. What if the mom started walking toward Mr. Daniels, and let's just assume there's no suspicion that she's going to enact violence upon him, or that she has in the past? Can they stop her? And if so, on what grounds?
I think that the officers could stop her if she's approached. It would depend on, is she lodging threats? Is her body language aggressive?
Yeah, I'm kind of suggesting no. So here's what the officer's justification is. And I just want to know if you think it works and if you have cases that support it. I don't think mom's going to hurt him. But this is a volatile situation, and these two are gonna, I can't let them be in the same room. So I'm gonna stop mom, which is not an RAS. That doesn't look like an RAS analysis. It's something else. It's maybe an exigent circumstances analysis. What's the right way to think about that?
I think that would fall under the officer's peacekeeping function, and this court recognized in Ball, quoting the Supreme Court in Fisher, the role of a peace officer includes preventing violence and restoring order, not simply rendering first aid. So I think that would fall under that, where it is appropriate to keep two individuals where 911 has been called for the police to respond. They have this history to just keep, and it's minimal, right? They're just keeping them separate, and you may even be keeping her separated because you fear what harm may come to her if she were to get past the officers and re-engage with her son. So I think that that is definitely a reasonable exercise under the police peacekeeping function. And onto the sufficiency. Here, there was, as counsel admitted, these statements are facially threatening. This court has held that, in Gray, I'm going to kill you. In Carell, I could fucking kill you. And as to the future part of that, I think that's Gray is the same. I'm going to kill you. That's the same threat that we have here. And this court found there was no issue with the kind of future temporal part of it. And that makes a lot of sense in this case where the parties do live together and he would have almost ample opportunity to carry out on this threat after the police left. Also looking at the context, there is this volatile hostile relationship. And again, the appellant's very serious, targeted, and aggressive tone when he is lodging the threats and directed towards his mother.
Wouldn't you also agree, though, the appellant appears pretty incoherent and out of it? And I mean, the very first threat that comes out of his mouth is, I hope God kills you. He comes back to that later with, I hope God kills you, you're going to die from cancer, et cetera. And why isn't this just a ramble? And why don't we read that in context of some of the other, or in conjunction with some of the other contextual pieces that Mr. Goldberg highlighted? Like the mother just never talks about being threatened and being worried about violence, just that it's too much, I'm being disrespected, et cetera.
So he isn't charged or convicted with the earlier threats about, the cancer, I hope God kills you. And I think that shows the escalation in some of those statements. He is seated on the bed or scrolling on his phone or smoking. But when he does make the threats of, I'm going to kill that bitch, I'm going to kill you, I'm going to show you why you should be afraid of me, I'm going to show you what hell means, bitch. He's up, his body language is different. He's more tense. The voice is escalated. So I think that does differentiate it from those
But the cops
early.
don't react at all to be concerned with it. They appear to have the situation under control. Like there's no actual interaction with him that becomes physical at all until he actually gets up and says he wants to leave his room. Not necessarily even in context of the threats, just I'm getting out of here. He seems to have his frustration escalate the more that he's held there. And so does that not give some kind of angle towards this as well, potentially? Like how do you address that? No one seems that worried.
I think that the body cam shows it's a little difficult to tell, but after he does say those threats, the officer does turn and start addressing. I think that's the first time that he calls for a transport, which kind of indicates that the officer thinks this is something different. This is progressing. And then he also turns and the victim is now saying something towards him. You can't really hear what they're saying, but it is some type of exchange about this is what he's saying. I think she says something about it being serious. It's very
Like he's
difficult.
directed towards, and she's saying, "Oh, it's me." He's talking to me. I caught that in the video.
Yeah, so I think that she is, and she's not reacting to the earlier ones. So I think that does kind of set this part, those words apart. In that they are different, they are aggressive, they are more targeted. And they are more similar to the threats that this case has upheld.
Yeah, let me ask you too. Neither of the parties focused on this, and I'll give your opposing counsel the opportunity to address it in the rebuttal as well. In our most two recent en bancs that are at least adjacent to this or directly on point with Carell and with Moore, we declined both times. Although in Carell, in the partial concurrence, partial dissent, Judge Thompson encouraged us to go so far as to consider whether recklessness could fit the mens rea. Do you have a stance on that? Because it seems to me that it would be a lot easier in this case to determine those threats, even if they didn't meet the absolute higher standard, were beyond a reasonable doubt, or just being very direct, or at least reckless.
Sure, it's not an argument that's been raised, so I don't have a position, but I would say that the intent, that the evidence here definitely does reach the purpose and knowledge, where he is saying the statements, they're very targeted. This is very similar to the case Jones, where this court relied on their tumultuous and emotional nature of the relationship, and that he later started yelling and gesticulating. So I think we definitely reached, there is more than sufficient proof of his intent in this case.
Much of this relationship do you think we can really determine from the record? We have some testimony, but it strikes me that this really comes down to this video, and this video seems to hold the entire universe of what we're looking at.
I think that's right, that the video is the evidence that we have of the relationship. And the fact that the victim calls 911 is something a little additional. But we do have the victim explaining that there is this back and forth, there is this ongoing issue. And we have the appellant's very strong reaction to the victim and what she's saying as she's speaking with the police, his side of the story, him saying her son assaulted me and lodging other complaints about the son. So I think that there is enough in the video to say that this is a hostile and tumultuous relationship that would add to the context of finding this is the type of case where there is an intent for this threat to be serious. There are no further questions. We ask that the judgment be affirmed.
Thank you, counsel. Mr. Goldberg, we'll give you a couple minutes for rebuttal.
Okay. I want to just address a few discrete points. On the question of recklessness, I think that the knowledge of the parties of the circumstances make it also not reckless. That's just not what what his mother would, or what an ordinary here would have thought. On the question of the government brought up the question of when the police turned to order a transport. And I believe from the video, although I have it in front of me, that that's right after the police hear what they view as a statutory threat. So it's not an escalation. In fact, on the question of escalation, I think it's not exactly right that this situation is continually escalating at all points. It goes up and down as he listens to his mother say things and he gets more upset or less upset. At one point, he makes what would be a threat and then lays back on the bed. It's not permanently escalating. A couple small points. I don't think it's exactly right that the mother gave consent. The police said, "We're here for the 911 call." She stands aside and says where her son is.
I think she said, "Come in."
I don't think I heard come in, but I could be wrong.
I heard come in, and I also heard the burn the house down, but
Okay.
you can
And if she
check
said
me
come
on
in,
this.
that would
but,
be an
yeah.
invitation. I can see that. On the question of, but at consent, he has withdrawn consent. He's on the lease, we know. He lives there and he withdraws consent for the police at least to be in the doorway of his bedroom inside. I think the judge finds that he's across the threat. The police are across the threshold. Last two issues that I have. First, I think in Clark,
Can I just pause you as it relates to the fruit analysis? Because I think it would be somewhat odd to say that if the violation is crossing the threshold, yeah, they're allowed to come in the house, but not allowed to step in his room. Well, then the threats seem very attenuated from that. I mean, it seems, why would the crossing of the threshold sort of be the thing that
Threshold of
caused
the-
him to issue a threat?
I'm sorry, I don't think I understand.
I'm saying, what's the causal connection between that violation and the threat having been uttered and heard? It's the "I'm going to kill you" doesn't seem because an officer has crossed into my threshold. It's that the officers are here. Do you understand what I mean?
do.
It's just a causal connection question. It
it's
seems
not-
hard to make out to me.
I see what you're saying. It's not the crossing of the threshold. They cross the threshold and stay and keep him in his room from a position they're not allowed to be in. Right? He said, "Get out." And aside from an exigency, which I don't think there was, they don't have a reason to hold him there, which they're doing from inside a place where they're not permitted.
So it's the seizure,
Yeah.
aspect of it that you're connecting.
Yes, they're seizing him from a place where they're not allowed to be. I think I disagree with the government that Clark does a Brown and Strife analysis. I just don't think it does that. And it just focuses on the second factor. Finally, the question earlier was, are there cases about statements? Two from our 28K letter, State v. Hellinger is about statements, and People v. Brown is about false statements to police, where the statements themselves are suppressed. If there are no other questions, thank you.
Thank you, counsel, for both sides. The case will be taken under advisement. Our last case this morning is 25 CO 361, Anthony FALTZ versus United States. Counsel, whenever you're ready.
Thank you, Judge Deal. May it please the court. My name is Jay Milliken from the Mid-Atlantic Innocence Project on behalf of petitioner and appellant Anthony FALTZ. If I could, I'd like to reserve 3 minutes for rebuttal. There are two primary issues before the court today. First, that the lower court in this case committed clear error in not fully evaluating the evidence before it for a second time. Second, that the lower court erred in admitting unreliable expert testimony from two government witnesses, the experts Miller and Chase. I'll start by addressing the first issue, and I anticipate using the bulk of my time discussing that issue. A full consideration of the evidence in this case on the record points to Mr. FALTZ's innocence. But for the second time, that consideration was not taken by the lower court. It made critical errors and critical admissions, which, as FALTZ 1, the original remand order, tells us is reversible error in the context of the IPA's mandate to fully evaluate or fully grapple with the evidence. Now, the most obvious example of this is this court once before pointed to stipulated officer testimony at the scene of the crash as a core piece of evidence that the lower court utterly failed to evaluate in its first order denying relief. And just for the court's memory or recall, what that officer testimony boiled down to was that Darrell Ingram got out of the front driver's side of the car and ran away. Mr. FALTZ climbed out of the passenger back seat. Now, this time, the lower court did make one very brief, I would describe it as prefatory acknowledgement of what the officer said, and then didn't discuss that evidence at all. Nowhere is there any further discussion of it. Nowhere is there any further analysis of it in the context of the overall record. By itself, that represents a failure to fully grapple with the evidence, as this court's remand order told the court to do in FALTZ 1.
So I guess my question is, yes, you can point to FALTZ 1 as well as Stringer,
Yes.
perhaps. But putting that aside, and maybe that's a crazy premise to have, but just taking a step back, thinking about the procedural posture we're in, yes, perhaps we can talk about reasonable doubt as to your client's guilt at this point, but that's not what the question is. So the question is, under an IPA motion, does new evidence, and here I think everyone agrees the new evidence was the presence of Mr. Ingram's DNA on the right edge of the airbag.
Yes.
Does that point to actual innocence? And so if we're starting with the premise that your client was guilty, I get it by a guilty plea and not from a jury verdict, but nonetheless guilty notwithstanding this eyewitness testimony that cut the other way. And so what prevents the trial court from saying, okay, here's the new evidence in the context of the IPA motion. It's Mr. Ingram's DNA on the side of the airbag. How does that point to what does that do vis-a-vis the eyewitness testimony that was already there at the time Mr. FALTZ pled guilty to this crime? Do you understand? I'm not sure my question is very clear, but.
I think so, Your Honor. I think you're asking me if the new evidence in terms of Mr. Ingram's DNA, what does that do in the overall context of the case?
Yeah, and
Yes,
specifically with respect to the eyewitness testimony that was already there when Mr. Faltz chose to plead guilty. And I know you have a whole slew of arguments as to why he chose to plead guilty or why he did plead guilty. And those are maybe related, but a little bit separate. But yes, that's the question.
Right. Well, I think the best way to answer that question, Judge Shanker, is that the DNA evidence, as this court has already recognized once before, really, well, for one thing, it speaks to the second error the court made in evaluating this case, which is how it treated the Miller Chase expert testimony. And it did so by effectively reading that DNA evidence out of the record, or at least out of its analysis. It mentioned it a couple of times, but that DNA presence of Darrell Ingram's DNA on the same driver's side airbag, as well as the absence of his brother Darrell Ingram's DNA from the passenger side airbag, essentially is significant contradictory evidence to the Miller Chase theory of how this crash must have happened and where the people in the car must have been. And so by ignoring that piece of contradictory evidence, and by ignoring the fact that the officer testimony was consistent with that piece of evidence, and then going on to credit Miller Chase and ultimately the government's theory of the case of what must have happened, that's where the government really made clear error. And that's how all this sort of the sort of tranches of evidence, for lack of a better term, really tie together in this case. All the physical and eyewitness evidence in this case, with the exception of the Miller Chase expert testimony here, really does point to Darrell Ingram being the driver. The DNA evidence is a core piece of that. It is not the only evidence, and by failing to fully grapple with all of that evidence, the court once again essentially repeated the error that it made in its first order.
I think one kind of gloss on what Judge Shanker might be asking, it's sort of is the tail wagging the dog here. So let's just take a case where I look at the evidence, somebody has pled guilty, and I look at the evidence that was available at the time, and I say, geez, they kind of look innocent by a preponderance of the evidence based on that evidence. And then some new, most trivial piece of evidence comes out that supports that claim, that I'm just trying to think of the most trivial thing I can, that, somebody's ID, Darrell's ID was in the driver's seat when you would expect stuff to be flying around that car in the accident. It's kind of a bootstrapping question. Do you just get a fresh look at everything? What if I think that evidence is meaningless, but nonetheless, the evidence as it stood before trial supports that this person is innocent? Do we just reopen everything for evaluation once we can get your foot in the door with some new piece of evidence that sort of by some iota suggest innocence? Does that make sense?
I think if you could clarify a little bit, Judge Deal,
Sure.
I think the evidence you're referring to specifically here would be the DNA evidence. Is that?
I'm not really trying to, I'm trying to offer a hypothetical. I agree with you that the DNA evidence is far more significant than the thing that I'm positing, but just imagine it was quite insignificant and it's just, the 100th best piece of evidence for this person's innocence and the other 99 had already existed. Do we just reopen everything on that ground?
I think, no, I don't think you certainly don't have to in this case, Your Honor. I think this is a core piece of evidence. And I think we're not arguing, and I don't think that FALTZ 1 or Stringer or any of the other court's cases in terms of interpreting the IPA requires a lower court to just look at every single minute piece of evidence and fully factor that into its analysis.
Right, but I guess, so the question, Judge Deal framed my question much better than I did, which is what I was getting at. But that if the court thought, and I realize you take significant issue with this, but if the court thought that Mr. Ingram's DNA on the side of the airbag did not move the needle for him, then my question is, why would it have occasion to reconsider the eyewitness testimony, which had already been there when Mr. Faltz was convicted of this crime?
I think for two reasons, Your Honor. First, if the court didn't think that the presence of Mr. Ingram's DNA really moved the needle, the analysis is really lacking as to why, apart from a couple of acknowledgments that it does exist, in terms of why the Miller Chase theory should be supported over the defense theory of how the crash happened. The second issue is I think it's also consistent with, it is consistent and it ties back to the eyewitness testimony in this case. That's why these two forms of evidence are really linked. And there's no effort either in describing the DNA evidence or describing, as once again, he did not grapple with the eyewitness evidence to really evaluate the exculpatory evidence here much at all, I think it's fair to say. And so that's really where the error lies. And that's where, again, the lower court failed to fully grapple with the evidence.
Can I ask about Daryl?
About Daryl?
Yeah, about Daryl, the passenger seat airbag.
Mhm.
I agree with you. I think it's somewhat, maybe quite troubling that the trial court does not seem to take into account the lack of DNA on that passenger airbag and how that can be reconciled with its crediting the government's experts that these airbags, you're going to hit it head on. And so my two questions are, number one, how clear do you think it is in the record? I think it was testified to at a preliminary hearing. I think it was in an arrest report, but maybe there's more that I don't know about, that Daryl was in that passenger seat. And number two, how strongly did you press this point before the trial court as informing how sort of egregious I would find it that a trial court wouldn't address it?
To answer your second question first, I raised it, I recall raising it in closing argument. It wasn't really pressed by either side during the hearing itself, except to the extent that Detective Miller said, and I don't recall if this was in testimony or his actual report, but he did say something to the effect that there was no real evidence that there were two people in the back seat. That we know there were three people in the car, and we know there was a driver. So there needs to be obviously somebody in the front passenger seat. There's certainly no affirmative evidence put forward that there were two people in the back seat. And so it wasn't really, and quite frankly, Judge Steele, it wasn't really aggressively litigated below because I don't think it was really particularly questioned by anybody. And so
I'm not asking sort of like, what's the evidentiary record? I mean, that is one of my questions. But I think if you were answering my second question first, it was just sort of how hard did you press that point? Although I'm curious, the answer to my first question is, are you familiar with more than, I think I'm going to get this name wrong, Officer Metivier?
Metivier.
His preliminary testimony, I believe he also filled out a report saying that Daryl, at least one officer saw him coming out of the front passenger seat. Have I about covered the universe of evidence about that?
I think so, Your Honor. I'd have to go back and double check that to answer that more completely.
I appreciate the point that but I mean,
Yeah.
for all I know, Daryl and Doral were locked into a story where everybody agreed that Daryl was in that passenger seat. And I didn't see stuff like that, and I just wasn't sure if there was more. So if there was, I wanted to give you the opportunity to provide it. Okay.
And so, and that really, all those questions sort of about the DNA really leads me into my second point that I've already sort of touched on, which is that, again, the DNA evidence, Darrell Ingram's DNA on the driver's side airbag and the lack of Daryl Ingram's DNA on the passenger side airbag, the court mentioned or acknowledged, obviously, that Darrell's DNA was on the driver's side airbag, but didn't really contend with what that meant. And that's really a problem because when you're crediting Miller and Chase, which is really, I think it's fair to say, the load-bearing reason why Judge Christian denied relief here was his belief in Miller and Chase and not Mr. Russell, a defense expert. He did not contend with the physical evidence and the eyewitness evidence that would contradict it. And that is really, again, a failure to fully grapple with. And I agree with you, Judge Schenker, that also touches on Stringer. It approaches something like a misstatement of the record. It catches out in the same place, leaving out large portions of exculpatory evidence, to my mind, gets you to the same place as just misstating evidence. And then compounding that, Judge Christian went on to, and again, we're back to Stringer here, to actually misstate a portion of the record when he seemed to imply or say that, and I quote, Mr. Miller and Mr. Chase testified that it would be impossible for the driver to miss the airbag. The court is not convinced that the driver would completely miss the airbag. Therefore, the new DNA evidence fails to demonstrate that defendant is actually innocent. Now, that is a misstatement. The idea that Mr. Faltz had to complete, or the driver had to completely miss the airbag was not our argument, and it wasn't Mr. Russell's testimony. In fact, he was very explicit about saying, don't misunderstand me. There is a possibility under my theory here that based on the rotation of the car at the moment of impact, that somebody could have skimmed off the side of the airbag. In fact, it is entirely consistent with the fact that Darrell Ingram's DNA was on the side of that airbag. And so for Judge Christian to seemingly say that because he didn't find it convincing that the driver would miss the airbag entirely, that I think puts us in the Stringer 2 universe of just misstating the record.
Can we get awfully deep into accident reconstruction here at everyone's peril? But so if the idea is that Mr. Ingram was in the driver's seat and his DNA was on the right edge of the airbag and it was based in part on the possible rotation of the car, am I understanding that the thinking is that the wheel was spun 180 degrees and what ended up being the right side of the airbag? Because the notion is that everyone went to the front left, right? So I'm having a hard time figuring out how the driver's DNA would end up on the right side of the airbag. Or is it that the steering wheel was upside down at the time the driver glanced off the airbag?
Effectively, and I could give you a more precise answer also on rebuttal, but effectively that's it. Is that the steering wheel, based on the position it was found in after the accident, was more than likely upside down. But I think the larger point that Mr. Russell made, the sort of big picture point, was that we just can't really know for sure about, given the dynamics of these crashes, we just can't really know for the government's argument that there must have been one way for this DNA to have been deposited is actually false because it's unknowable. I mean, this all assumes there was even direct contact as a result of DNA. It could have been both the defense's DNA expert and Mr. Russell himself testified that saliva, for example, is a rich source of DNA. Everything in a car, in a high-speed T-bone collision, saliva, blood, people are flying around all over the place. And the level of precision that Miller and Chase attribute to, we know it was direct contact and we know it was from the driver, was really can't be supported.
So sorry, go ahead.
Please go ahead.
Well, so just to wrap that up, is then at a very high level, is your position, your client's position that, and based on Mr. Russell's testimony, that the DNA becomes a wash in this case at some level because no one knows what happened with it? And so what are we left with at that point? We're left with the eyewitness testimony? And
that is sort of the weak version of the argument, if you want to put it that way. The stronger version is it is more likely that everyone went off to the left and possibly made Mr. Faltz made direct contact with the center of the airbag and Mr. Ingram skimmed off the side of it. And therefore, it is more likely that Mr. Ingram was the driver than Mr. Faltz. But at minimum, even if you are not willing to go that far, at minimum, the uncertainty involved here as to DNA placement in a high-speed accident, what we're left with is eyewitness testimony, which clearly said that Darrell Ingram was driving, and that would mandate, under the IPA standard, a new trial.
All right, thank you, counsel.
Thank you.
We'll give you a couple minutes for rebuttal and we will hear from the government.
Good morning. May it please the court, David Sable on behalf of the United States. Turning first to the questions from Judge Deal and Judge Shanker about the procedural posture, I think it's vital to remember that. Unlike Stringer, which was a trial, this was a plea. And this was a day of trial plea where the jury was standing in the hallway and the plea offer was re-extended. He took it, they put the proffer together, probably wish they'd had that more time on that one, right? And then he takes the plea and says, and that's where we are. So the Ingrams never testified. They were going to testify that Faltz was the driver. We don't know what they would have said about who was where, who was in the front passenger seat. The pedal throwback injury, what would an expert have said about the pedal throwback injury and the injury and the dislocation of the right hip? We don't have that. The cross-examination of the officer witnesses, we don't have that. Judge Christian is now looking back 24 years at officers who never came into his courtroom trying to make determinations about this. So that's important to remember. And the reason for that is so important is, as you said, Judge, or you said, that we're not looking at beyond a reasonable doubt. It's not our burden anymore. He's presumed guilty. He has to show under the statute by clear and convincing evidence or by a preponderance, evidence of his actual innocence. And I think in fairness, what I think you're getting at is, look, don't we want to say that you have to put forth a quantum of competent evidence of actual innocence before the judge is then obliged to then go back and try to figure out all of the probative and not, all the evidence that points different ways, especially in a plea case when it's a day of trial plea. It's difficult to do that, right? So in this case, there has to be a quantum of actual innocence evidence.
What do you think, A, where do you think that bar is? And B, why isn't Darrell's DNA on the airbag? Why doesn't it clear that bar?
Okay, well, first of all, the evidence comes in a couple different buckets. First, we had the evidence from FALTZ, discredited, affirmed on the first appeal, right? So there's no evidence from FALTZ here of his actual innocence. The second evidence would be the DNA evidence, the probabilistic genotyping from Dr. Rudin. That was credited. But what the court said is, standing alone, that's not probative of guilt or innocence. It only.
But it's not probative? You think the court said that's not probative of guilt or innocence? I thought what the court said was that doesn't establish his innocence. I mean, those two things are wildly different, right? A brick is not a wall. You need many bricks to build a wall, but saying that something is not a wall in itself doesn't mean it's not a brick, doesn't mean that it's not probative. So
Take your point, Your Honor. I think in this case, what the court said, it doesn't move.
You say it doesn't move the needle? I don't remember that.
I was going to say move the needle. Did I say that?
I said move the needle, but so
That
that
was, that's what happens when a bunch of lawyers get together. We all come up with the same analogy. Right. What I'm not seeing it immediately, but what the DNA evidence does not itself establish actual innocence. And I would say
that's sort of a funny thing to say. I mean, it doesn't have to, right? I mean, I think you agree with me, it doesn't have to.
okay. So Judge Christian, yes, he could have said, and I would say to you that the evidence is not sufficient for us to necessarily then have to reevaluate all the evidence in the case.
Except we've already crossed that bridge. There's a lot of the case that you need to take it, Judge Christian, you need to take into consideration the multiple officers IDing who came out of that driver's side. That was part of our remand.
Yes, I know.
And it doesn't say a word about it.
Well,
That's wild.
Judge Christian doesn't like to be micromanaged. What do you want me to say?
I mean, it's a very,
Right.
it's a remarkable thing. And I don't know how.
Here's the thing.
Uh-huh.
Here's the thing. When you're a judge, you get to wear the black robe and a witness comes before you and you're the finder of fact. And the witness says, this is what happened. I did this, I did this, I did this, I did this. And I say, I credit the witness. Guess what? You don't have to make all those factual findings. You just did. So when he says, I credit Miller, I credit Chase, and I discredit Russell, that's it. And so that's why we made the arguments that we made. And I would say, if I were in your shoes, yeah, I probably wouldn't. I wanted Judge Christian to say it explicitly, but he said it implicitly. And you can say, I don't like it, but it's not an abuse of discretion.
What if we had video evidence of Darrell getting out of that driver's side? And, 20 nuns on the scene who all testified consistently that they saw him get out of that driver's side. But Judge Christian says the same thing as he did this time. And he says, well, their expert says it must be the driver, that FALTZ must be the driver. And so I credit that witness without talking about the 20 nuns, without talking about the video evidence. Are we stuck with that? Or would we say, come on?
You're not stuck with anything. You have a clear error standard of review.
Okay.
Okay, so apply your clear error standard of review. You applied it as to FALTZ. Now you get to apply it as to his determination that Russell was incredible and that Miller and Chase were credible. And if you think it's incredible, or if you think that's clear error, you could say that.
But what if I
Oh.
just think it's bound up with the stuff? Whether or not these experts are credible is not a determination that one can rationally make without taking into account the lack of DNA on the passenger side airbag, without taking into account the officer testimony about people getting out of the car as to that the consistent testimony that it was Durrell. So, those seem very relevant to which expert is the more credible one. Now, they might not be decisive. I'm not saying that you must, uphold the eyewitness's account above what experts posit must have happened. But it sure seems like if I'm making a credibility finding, to me, it's a little bit like the elephant in the room. It's not like a small thing. It is multiple officers. The thing that led them to charge Durrell originally with these murders, originally a second-degree murder, if I recall correctly, was these officers' testimony, and he doesn't even want to talk about it when assessing which officers have, which experts are more credible.
Look, you can send it back if you want, but don't get one thing twisted. FALTZ killed two people. Okay, so we can talk about the facts of that, but he killed two people. And I want to say a couple things.
Well, he only killed two people if he was the driver, right? I mean,
Exactly.
right. So-
Exactly. So to get into the weeds, I mean, we could be here all day talking about this, but I would like to make a couple points about the driver. Maybe first about the passenger side DNA, if I can. So Kimberly Metivier was the lead detective initially, and she was not on the scene when anybody was getting out of the car. You have to look at, I would suggest, direct the court to look at Pfeiffer's grand jury testimony at 7 to 8. And that's where he makes the comments, not only about the car, the Crown Vic going 10 to 15 feet, which they don't like in a straight line, but also says that he went around to the right side of the car and saw FALTZ getting out of the driver's side. So the right side of the car is the passenger side of the car as he's approaching the car, right? Because he's pointed, he comes right, car crash happens, car spins around. Pfeiffer drives up in the first vehicle. Hodges parks around the corner. Pfeiffer's here, car's here. He walks over here. Now they give us a lot of, a hard time for our theory, but we, again, don't have to explain what happened. But there's a lot of confusion in Pfeiffer's grand jury. He goes around to the right and he sees FALTZ getting out of what he thinks is the driver's side, which we think is possibly the right rear passenger.
He said rear, right? Driver's side, but rear door.
So the car spun around, and
Right.
what he says on 7, it looked to me like, okay, sorry. I ran over to the passenger side of the vehicle. On the right side, the rear, one of the passengers was exiting the vehicle at the time, which, if you think he spun around, is the driver's side of the car. If you think he's got the car right, is the right rear passenger side.
Right. But either
And
way.
then he says he grabs FALTZ, because FALTZ has a dislocated hip, and he takes him around to the other car where two people are getting out of the other side of the car.
Before you go further, if you could help me, either which way, that'd still be the rear, right?
Sorry?
Before you go too much further beyond this, like whether it's spun around and he's getting him from the rear passenger side or the driver's side, it's still the rear, right?
Well, when he gets out of the car, the front of the car is pointing at the police car because it's done a 180 during the course of the crash. That's why we put the photo in the brief.
Right, but it's the rear door. It's a 4-door car.
It's a 4-door boxy car.
Right.
Right.
And so it's the rear door.
He says it's the rear door,
Right.
which would be the driver's side door if he's mistaken about the sides.
Right, but putting aside, Judge Howard's question is put the sides aside. And we're talking about just which rear or front, and it's rear, either way, he says.
Well, I mean, I understand him to be saying the right as to him, the rear as to him.
Okay, I mean.
Am I not answering your question?
Not exactly, because regardless of whether he's looking at the front of the car or the back of the car, or he's confused about that, there are still front doors and there's back doors. And he said the back door whether he was saying right or left or driver's side or passenger side, he was saying the back door.
So if he, let's say okay, well then it's possible he ran around to the right. And that if he were properly oriented to the car is facing him, the rear door would be the second door, the one farthest away from him. That's what I think you're saying.
Right.
In which case he would be sitting in the rear on the left-hand side behind the driver in that case.
Yeah.
So,
Okay, well,
but again, Pfeiffer never testified. These were all things that would have been helpful to hear from Pfeiffer on cross-examination, and the plea happened notwithstanding that.
I mean, you guys could have developed this as part of the IPA hearing, though. I mean, I appreciate, you might say it's too stale, you know, these officers aren't going to remember a thing.
I wouldn't say that.
But
yeah.
I'm pretty sure if you ask these two officers, is it possible you confuse the front driver's side door with the rear passenger side? They would say, not a chance. Because who would? I mean, they've just witnessed the accident. One side of the car is smashed up. It's got an airbag deployed and a steering wheel there.
Two people just died. It's a high-speed chase. It's a highly chaotic, emotional moment.
I mean, those officers' testimony would have been extremely powerful against Durrell had you guys stuck with your charges against him, and they seem extremely exculpatory. And I appreciate, you know,
That's why it's such a
maybe
trial
you should get a
case.
trial. No, I understand. I appreciate the point. I'm still just, you know, sure wish the trial judge said the sort of stuff you're saying now, and I don't know that you get out from under an omission when we tell a trial judge, hey, consider this, and then he doesn't. I don't know. I don't know, counsel.
That's
I think
between
it's
you
a
and
tough.
Judge Christian.
Fair enough.
Have a cup of coffee with a guy. I don't know. But
You can disabuse me of this notion too, and just clarify some of the procedural history after we sent it back with FALTZ 1. It looks like this decision was, am I wrong to think of it as fairly rushed? It looks like there wasn't really much of an opportunity to do argument, that there was an initial filings and then, you know, no hearing scheduled, nothing further. And the judge just came out with the ruling that came back to the original point came back to support the judge's original ruling.
I'm fairly certain, I certainly wouldn't say it was rushed. I'm fairly certain that there was Mr. Miller can probably say more. I don't believe there was a hearing. Yeah, it was, so he simply he wrote another order.
I get that there's been a long time between things, and what do we really expect from another hearing and whatnot, but sorry, go ahead.
So, right, Judge Christian has had this case from the beginning. A couple points, I think it's really important. On the airbag, Your Honor, I think Mr. Milliken was candid about this. It wasn't really pressed at the hearing. The government's expert
The
did.
passenger side airbag, you're saying?
Yeah, I'm talking about the passenger side. The government's expert did say, if there were somebody in the front passenger seat, I would expect their DNA to be on the airbag. That is true. The defense expert said, we don't know if somebody was in the front passenger seat, although it would be unlikely to have two people in the rear seat. The record that we have is equivocal about who sat where, about whether anybody was in the front passenger seat. And the only thing that is accurate, contemporaneous, would be Pfeiffer's grand jury, which I would submit to you is equivocal about whether there were two people in the front seat or two people in the back seat.
When you say the only thing we have from a percipient witness, because we do have the Metavier preliminary examination testimony and arrest report that Daryl got out of the front passenger seat.
Right, but that's all trial stuff that you could impeach her with, but
Oh, sure.
she didn't see it.
but I thought Mr. Miller said,
You're asking a detective who's testifying based on hearsay.
Just wanted to make sure I understand what you meant when you said the only thing. You mean the only thing we had from a percipient witness sort of testifying under oath was Pfeiffer's statement in the grand jury.
Right, and Hodges saw Darrell Ingram get out of what he thought was the driver's seat, and Pfeiffer saw the only person that saw FALTZ get out of the car was Pfeiffer.
didn't Mr. Miller say that there was nothing in his expert analysis of the car, of the vehicle, that suggested that there were two rear seat passengers?
He might have said that. There was no evidence from the experts that they had any idea whether there was two people in the back or two people in the front. And the defense expert said that as well. So, but getting to your point, so again, we don't think it was not pressed at the hearing, and well, that's the development on that point. But I want again to say that yeah. So one thing that I guess I'm not going back to the overall assessment of the evidence. I'm sorry, going to the police eyewitness testimony particularly. What Chase said in his supplemental report was, look, if you eyewitness testimony can be variable, particularly in an emotional moment. If you have science that points one way and you have eyewitness testimony pointing another way, go with the science, believe the science. Chase has that in his report. Chase is credited. I understand, I'm not going to argue with you that Judge Christian could have written a sentence along the lines of, I'm presented with scientific testimony that I've credited that establishes that Faltz was the driver of the car. It defeats his claim of actual innocence. And I'm presented with contradictory eyewitness testimony from the first officer on the scene. I'm going to credit the scientific testimony and weigh the officer testimony less and find that under the standard, which is not beyond reasonable doubt, but which is the defendant's burden, that he has not shown actual innocence either by a preponderance or by clear and convincing evidence. That is the implicit finding that he's made. Turning to the idea of the one reason to discredit the defense witness, Mr. Russell, is that he says that Officer Pfeiffer swerved to the right. He says this multiple times, that he swerved to the right. And again, if you look at page 7 of the transcript, what Officer Pfeiffer said was, it looked to me like the Crown Vic sped up and aimed the vehicle into the car and collided with the car, pushing the car, I guess, probably about 10 to 15 feet. Nowhere does he say that the car turned at the last minute. Nowhere does he say that the car was rotating, that the steering wheel would have been rotated 180 degrees at the time of the collision. And the scientific testimony says that when two cars crash in a frontal collision, the first thing that happens is they crush into each other. They crush into each other, and then there's a period of what they call maximum engagement, and then they start separating, which is when the Crown Vic would have started spinning. Crushing happens at about 100 milliseconds. The Crown Vic airbag deploys in 40 milliseconds and deflates in another 10 milliseconds. That's why no matter how much the spin happened after maximum engagement, no matter what happened about whether the car slid 10 or 15 feet or not, what Chase said was the airbag would have deployed before maximum engagement. The driver, an unrestrained driver in a frontal collision, would collide with the front of the airbag. And that's why it's so probative that Faltz's DNA is in the center of the airbag. And let's recall, the amount of DNA in the middle of that airbag was 34 times, according to Dr. Badoli from the FBI, 34 times the amount of the DNA on the side, and probably more than that because they used a more sensitive kit for the airbag on the side. That's a lot of DNA. Okay, is it beyond a reasonable doubt? Well, I wish we'd had a trial to show that, but it certainly doesn't establish, their evidence certainly can't impeach that evidence. Looking at Faltz, I'd like to say something about Faltz. I know that the court affirmed Faltz's testimony, but the court did evaluate on remand, as the statute requires him to do, the reasons for pleading guilty. One of the things that Faltz was arrested that night. Faltz was arrested. They were all arrested. Durrell gets charged with second-degree murder, and Faltz is no-papered. Faltz is interviewed by Metivier that night. He says, look, we know you weren't the driver. We know you weren't the driver. Just tell us who the driver was. He gets no-papered. What's the lesson? You got to be the driver to be charged with this crime.
Can I ask a question? Do you know if he said Doral or Daryl?
I don't know what he said. I don't have his statement.
I thought you were about to tell me he said Daryl, because that would seem awfully good for you. But okay.
I don't know what he said.
Uh-huh.
I don't know what he said, nor do I have statements from the Ingrams.
Sure.
I wish I did. So at this point, then they go, so Durrell gets charged. Doral gets charged. Then the DNA comes in. Doral gets dismissed. And now FALTZ gets charged with an arrest warrant that says you're being charged because the government's theory is you are the driver. And so now, and he talks to his lawyer and his lawyer says, here's a plea offer. They're charging you as the driver. And he admitted in testimony, I knew I was being charged as the driver. Do you really believe that he went into court and said, I'm pleading guilty and I'm pleading guilty as the passenger? He could have said, I'm pleading guilty. I wasn't the driver, but evidence was against me. I didn't think I had a chance. That's not what he says. What he says is, I pled guilty thinking I was guilty because I was the driver, because I was in the back seat. That just does not wash at all. That's an out and out lie. Judge Christian knows that. One reason that I think Judge Christian is so dug in on this case is he saw this and he knows that he's lying, and he's testified 3 times, plus the plea proffer. FALTZ is lying, lying, lying. He knew in 2006 when he took this plea that the only way that you can be guilty of this crime, and remember, he had been arrested before, is if he was the driver. He knew he was pleading guilty as the driver. And afterwards, he semi-recants to the PSR writer, happens all the time. We know this, right? And then he talks to Bond, and Bond says, you cannot go to sentencing if you were the driver. That's going to be a red flag at sentencing. Were you the driver? And he says, yes, I was driving at the time. Very, very clear.
I take the point that sort of it is somewhat incredible that one would think on this record that he believed he was pleading guilty as the passenger. But one thing you said, I want to give you an opportunity to respond to what Mr. FALTZ has asked for. If we think Judge Christian did not undertake the necessary analysis of the officer identifications, the lack of DNA on the passengers, maybe, what if we're not going to do that in the first instance? We think that needs to happen. You also described Judge Christian as being so dug in on this case. And one thing that Mr. FALTZ asked for is for this, if we do a remand, to assign it to a different judge. I don't think you responded to that in your brief. If you did, I missed it. And so if you haven't and you would like to respond to it now, I want to give you an opportunity to do it.
I hope we said a footnote and cited Litecki.
It's possible I missed it, but say it again.
We would have cited Litecki.
Okay.
It's Justice Scalia's opinion. Have you read the motion to recuse from my opponent? It's insulting. It's absolutely insulting to Judge Christian. Judge Christian has an opinion about this case. Judge Christian probably has an opinion about Mr. Milliken. Judge Christian formed those opinions based on years and years of litigation inside the courtroom. Things that happen inside of the four corners of the courtroom are not bias. They are learned experience based on this case. Obviously, I don't know what Judge Christian thinks of Mr. Milliken. I'm just saying that it seems like they're not getting along based on the motion to recuse.
And I see you did cite Litecki, and it is the last footnote in the brief.
Right.
So it's there.
This is not something that happens outside the courtroom. This is something that's happening within the 4 corners of the courtroom. And I would just say, from a pure fairness point, nobody else is going to be able to understand this case the way Judge Christian does. Nobody else. And you are going to say, because you've said this in other cases, this is what happened with Judge Becker. Judge Reed Winston and Stringer recused herself because Ricky Charles had lied in front of her so many times. She thought, well, I'm not going to believe this guy. I wish she hadn't done that. If we lose Judge Christian, then he's not going to be able to say, the new judge won't be able to say, FALTZ has lied multiple times, and I know it because I sat there in the courtroom and I looked at him. The new judge will not be able to say that. It'll be a huge loss to the government, and I think an unfair one.
Thank you, counsel.
Thank you.
We will give you a couple minutes for rebuttal.
Thank you, Your Honor.
A couple of small points, judges, before I get to the more substantive reply. First, to just sort of close the loop on the question about evidence that Daryl was the passenger side. That actually was stipulated to by before the evidentiary hearing. It was, and this is note number 25 in the stipulation, MPD officers identified Daryl Ingram as the front passenger. And they cited to police reports, and we can go back and argue about the ground level truth of those police reports, but that was stipulated to.
Not that he was, but that officers identified him.
Well, the stipulation overall said that, held that the facts listed below are true and accurate, and then it went into all
True and
the
accurate
other-
that officers identified
It-
that, not necessarily that he was, right. I mean, it's,
So I would say presumptively true.
sure. Maybe.
So just to sort of finalize the point on that, a few other things that Mr. Sable raised. He talked about a quantum of competent evidence and asserted that we didn't present that in this case for innocence. Your Honor, I think we do. I think we have the DNA of the chief alternate suspect, the person who was originally arrested for this crime on the driver's side airbag. We have unanimous eyewitness testimony that Anthony Faltz was not the driver of the car. We have a qualified accident reconstructionist, Mr. Russell, saying it was more likely based on his.
Definitely not unanimous, right? Because you've got two witnesses that are going to say he is the driver of the car. We know about that.
Unanimous, disinterested observers, let's put it that way, in terms of the police officers. If you're referring to the Ingrams.
I'm referring to the English,
Okay.
yes.
The disinterested observers did say that Anthony Faltz was not the driver of the car. We have a qualified accident reconstructionist in Mr. Russell saying it is under his understanding of the basic laws of physics that it's more plausible that Mr. Faltz hit or left DNA on the center of the airbag from his position as a backseat passenger or in the middle of the backseat than he would have as the driver. And to the extent that you can
you just, I'm curious, I don't recall looking at Miller and Chase's report for this. Because I understood them to primarily be saying, you know, you would, the driver would make contact with the dead center of the airbag. Did they address the likelihood of a rear seat passenger hitting the airbag?
In the reports, I don't think they did. In testimony, we confronted with them, Mr. Chase specifically in cross-examination, and he said I don't recall if he said he was surprised to learn that there was no DNA or that he hadn't really thought about it in terms of.
No, I'm not talking about no DNA. I'm not talking about the passenger airbag. I'm talking about, did they address the likelihood that a rear seat passenger would deposit like the quantum of DNA that they have from Mr. Faltz on the driver's side airbag? I appreciate, so two different things. One is they definitely say the driver would have hit that airbag, and that points to, it would have hit it head on. And that points to Faltz as the driver. Do they say, and a rear seat passenger would not? Do they address that?
I don't, honestly, Your Honor, I don't recall if they said.
I don't either, but I can.
Not possible. They did say, I would say the core of the report was that it was impossible for the driver not to hit dead on.
So can we just get into how you actually confront those facts? I mean, so even if Mr. Russell's theory is that Crown Vic rotated, we've got this 100 millisecond versus 40 millisecond. I think everyone agrees with those numbers, if my understanding is correct. And it's simply impossible for the airbag to have not inflated and made impact with the driver before it started spinning under those numbers. So what's your response to that?
So I think there are two ways to respond to that. First is that if it was always true that somebody would hit a driver's side airbag dead on, we would have no need for side curtain airbags, for example, which we know we do.
I'm sorry, for side impact airbag?
Yeah.
Well, but not
forward and then move to the side.
well, and also you might have not a full frontal if those would be implicated in non-full frontal collisions, right?
Well, this wasn't full frontal collision into a fixed point, which is one of the things, I mean, the irony here about and I'll return to the sort of core of your question in a moment, but I think one of the ironies here of both Judge Christian and the government sort of discrediting Mr. Russell's exemplar videos of people missing the airbag is that the deployment speed of the airbags that Mr. Chase really relies on really is in the context of a full frontal crash into a fixed object, not a T-bone collision with multiple moving objects. But I think to answer your question more directly, Judge Schenker, Mr. Russell basically said, well, the airbag deployment speed is relevant, but the more relevant point is the movement of the occupants of the car during and even before the crash. And he speaks to evidence that Based on the turning of the wheel and based on officer observation, there was a good chance that people in the car were already rotating to the left when the crash actually happened. So you're not starting from sort of zero, and here the limits of my liberal arts education become obvious when we're discussing the physics of this. But you're not starting just, straight ahead, crash, boom, straight ahead. If you're already rotating to the left, then obviously the equation is going to change. And that was really his core finding on that point. But to go back to my earlier point about,
Can I keep you on that for a second? Because Mr. Sable has asked me to go read pages 7 and 8 of the grand jury testimony from Officer Pfeiffer, which he says, and I have not read it, so I'm not sure what it says, but he says it does not support a turn. I think this is what he said, that it doesn't support that the car sped head on into the Altima. It doesn't support anything that it turned to the right. Is that correct? I mean, what is the evidence that you're telling me that the car turned before the impact? What's the evidence of that?
Well, I think part of the evidence is that officer. I would disagree somewhat with Mr. Sable's characterization of that testimony, but basically, Officer Pfeiffer testified, or would have testified, observed that the car appeared to be taking some sort of evasive action immediately prior to impact, which is not at all uncommon in crashes like this. Obviously, it didn't take enough evasive action because it crashed head on. But also given the position of the steering wheel and a number of other sort of physical factors that Mr. Russell identified, and I can supplement this in writing if the court would like to know more. But that essentially there was evidence that the car was already, or more to the point, the people in the car were already rotating to the left at the time of impact. I don't know if that fully answers your question, Your Honor. Like I said, I'm happy to supplement in writing if the court would like.
No need from my perspective. I'm reading through the grand jury testimony now, but I'll piece it together as best I can.
In any event, this actually goes to a larger point. Mr. Sable talked about the Judge Christian has sort of the right to credit certain experts and not credit other experts. And in a vacuum, that's true. But of course, you can credit the expert if you ignore all the evidence that is contrary or that would undermine the expert. If you ignore, and again, the government would like to have this court understand that this is a conflict between eyewitness testimony and scientific evidence. It is not. It is a conflict between eyewitness testimony and physical evidence, namely the DNA evidence, and two different theories of accident reconstruction. So if you're going to ignore, if the lower court is going to ignore the eyewitness testimony saying that Anthony Faltz got out of the backseat passenger side, if you're going to ignore the fact that Darrell Ingram's DNA was also on the driver's side airbag, if you're going to ignore the fact that Darrell Ingram's DNA was not on the passenger side airbag, which presumably deployed just as quickly as the driver's side airbag would have, of course you're going to credit the Miller-Chase theory, but that's not the kind of analysis that I think Stringer 2 mandates. When you credit witnesses, you have to do it against either demeanor or record evidence. This was not a demeanor decision. This was based on record evidence. And the record evidence here points in the other direction. So that's not real analysis. That's cherry picking. And I think Faltz and Stringer both tell us that that's not good enough. And then the final point, Your Honor, I know I'm past my time here. As to our request to reassign, I know it's a little bit of an unusual request and it's probably an unusual grant, but the issue here is not just what happened in the courtroom. Although having done the closing argument when Judge Christian sort of announced that he didn't think, why would Mr. Faltz have pled guilty if he wasn't actually guilty? I know I'm not a testifying witness. I certainly was taken aback by that statement. But this was a judge who we needed to file a mandamus to have him rule on our motions about whether or not Mr. Faltz was going to be able to testify remotely, about whether he was going to be brought over for his hearing. We had to continue the case at least once because he would not rule on our motions to exclude expert testimony. He would not rule on our motions to have the court cover costs for our experts. He would not rule whether on Mr. Faltz was able to be brought into the courtroom where he was going to testify. That's just one extreme example. And so I think, again, it might be considered an unusual remedy, maybe even an extraordinary remedy. But in this case, I think Mr. Sable unwillingly sort of said the truth, which is that Judge Christian really does seem to be fixated on this guilty plea and kind of can't get away from that. And here you are really not seeing twice now an effort to fully evaluate the evidence that might sort of contradict his belief in that guilty plea. And as to whether it was convincing in the first place, of course it had to be a convincing guilty plea. If it wasn't a convincing guilty plea, he's ethically obligated not to accept it. And then you go to trial with an attorney, when we've litigated this before, with an attorney who effectively just told you it's not a winnable case. So I don't think the fact that the guilty plea seemed convincing is of any real relevance to this court. And unless there are further questions, I'll submit.
Thank you, counsel. Thank you, counsel, for both sides. The case will be taken under advisement and the court stands adjourned.